Listen-only mode.
Hi, I just want to let everybody know that we're actually here. It's 6:57 on my computer clock. We still have some people signing in, so we will start promptly no later than 7:02. Um, all right, thank you. Okay, good evening. Welcome to Scores. of Bucks County's Wednesday webinar. This Wednesday night, our topic is workman's compensation. For those of you who are unfamiliar with SCORE, SCORE is a national organization. My name is David Boster. I'm with the Bucks County chapter of SCORE, and SCORE is a nonprofit organization made up of volunteers. Most of us are retired or semi-retired, and our mission is to help and educate small businesses and entrepreneurs looking to start a business. At the same time, we offer free one-on-one mentoring for those of you who have particular issues you want to discuss, business related. Whether you own a business or whether you're looking to start a business, we can help you. So without any further ado, I will introduce Chris Cackline, who is a partner in the Chartwell Law Firm. Chris is an expert in workman's comp law, and Chartwell, one of their areas of specialty is to work with businesses and to help them protect their rights with regard to workman's compensation. So at the risk of getting into some legal snaggle that I know nothing about, we'll turn things over to Chris. Chris, the floor is yours.
Thank you very much. Good evening, everyone. Glad to be here to talk to you tonight about workers' compensation, a topic that hopefully you don't know too much about, because if you do, that means some of your employees
Hello?
have had workers' compensation
Oh.
claims. So we're going to start in a very basic, on a very basic topic. What is workers' compensation insurance, and why do small businesses require it? Workers' compensation insurance is an insurance that's purchased by employers, and it provides a layer of coverage for liability for workers' compensation benefits. The Workers' Compensation Act in Pennsylvania compensates injured workers in three ways, which we'll talk about a little bit. It can provide compensation for physical injuries or psychological injuries stemming from a specific incident. It can compensate workers for diseases that are developed as a result of some type of exposure in the workplace or some other type of repetitive injury, and it can compensate for medical benefits for those injuries. So in Pennsylvania, employers are required to pay for those benefits through the Workers' Compensation Act. Small businesses can purchase insurance for workers' compensation through your brokers that might provide premise liability insurance or general liability insurance, or in Pennsylvania we have an insurer of last resort, that is the State Workers Insurance Fund, which if you cannot get a policy from any private insurer, the State Workers Insurance Fund by statute must insure the business. Because it's mandatory to have workers' compensation insurance, you have to have a place to get it. Okay. How does workers' compensation insurance help the employer? Well, it's mandatory. The one way it helps you is to not face criminal or civil sanctions, which we'll discuss in a little bit. We'll talk about how and when a business is required to carry workers' compensation insurance, and we'll talk about the penalties for failing to carry workers' compensation insurance, and then we'll talk a little bit about what a claim looks like, what are the types of benefits at issue, how you can mitigate your loss if there is an injured worker who has a catastrophic injury or an occupational disease or things of that nature. You'll have to bear with me. There's a bit of a delay between me changing the slide and you being able to see that change in the slide. Okay. Sorry, it's going back and forth. Okay. Failure to carry workers' compensation insurance can have some pretty dire consequences. Um, Criminal fines, criminal penalties, including possible jail time for maliciously either misclassifying your employees as independent contractors or simply knowingly refusing to purchase workers' compensation insurance are all possibilities. There is a fund in Pennsylvania. You'll see there it says UEGF. That is the Uninsured Employers Guarantee Fund. It's a fund in which revenue from taxation is put into a pot where injured workers can receive benefits even if their employer is uninsured. That Uninsured Employers Guarantee Fund then has a right of action back against the uninsured business for reimbursement of those benefits that are paid out. So if you're uninsured and one of your employees has a work injury, the UEGF will not very politely ask for you to reimburse them for any benefit paid. They'll refer the case to the Attorney General's office, who will then levy criminal charges and or assess penalties and possibly charge ownership with criminal violations. While they're misdemeanors, enough of them can still result in jail time. If you're a construction company, there is a specific act in Pennsylvania that allows for greater criminal sanctions, including criminal charges and fines, which get fairly extensive, if that construction company knowingly and maliciously misclassifies its employees as independent contractors. Now, the test for independent contractor in Pennsylvania is very similar to the federal taxation test for independent contractor, whether your income is coming from independent contractor or if it's coming from employment. The same test applies, and that test is not enumerated in our Pennsylvania Workers' Compensation Act, but the elements come from case law and are pretty clear. And this will not only apply to construction companies, but it will apply to really any company that has employees or independent contractors that are difficult to classify. Some of the characteristics of an independent contractor are freedom to make schedule for themselves, freedom and control over the manner in which the work is completed, the method of payment. So if you're paying a person via a 1099, not withholding taxes and paying them on a job-related basis versus a salary, even an hourly related basis would be grounds to be more of an employee rather than an independent contractor, but not dispositive of the issue. Those are the considerations that are taken into account when determining whether or not someone is actually an independent contractor versus an employee. So the example that I have here, and this again doesn't just pertain to construction companies, but really any company that might hire what they think is an independent contractor. So in this example, a general contractor, which is made up of a partnership of 3 owners, hires a subcontractor as a 1099 independent contractor for a roofing project. While that roofing project is going on, one of the subcontractor's 10 employees has an injury. The subcontractor, unfortunately, does not have workers' compensation insurance. So the question is, who pays that benefit? Who's going to be liable for payment of workers' compensation benefits for that person who clearly had a work-related injury? They were injured on the work premise, although the work premise was in control of the general contractor. Um, and the question becomes much like I've already discussed. Who is controlling the manner in which that employee or that worker is doing the job? Who's in control of the tools that that person is using? Um, and the answer is not clear. In some cases, it will be the subcontractor, and the uninsured employer's guarantee fund would pay the benefits, go after the subcontractor civilly and criminally, and work from there. The injured worker shouldn't suffer just because his employer is not covered for workers' compensation insurance. But if you're the general contractor and I'm your attorney, I'm going to be upset with you because you didn't get certificates of insurance from your subcontractor regarding proof of workers' compensation insurance. So the Zullinger Meats Incorporated case is an example of why you need workers' compensation insurance. In 2008, the president and vice president of this meat company faced criminal charges for failing to carry workers' compensation insurance for just under 300 days. They faced $750,000 in fines. They both had 299 counts of a misdemeanor 2 that could have carried significant jail time. They settled their case for not a $750,000 fine and no jail time, but they paid substantially more than they would have in workers' compensation insurance premiums. So that's a cautionary tale of not having and knowing that you need workers' compensation insurance and simply not carrying that type of insurance. So much like we talked about before, there is a test that is put forth in Pennsylvania workers' compensation to find an employer. So where the Workers' Compensation Act can find an employer and not tax the UEGF for those types of benefits, it will do that. And in that general contractor example that I gave before, there's a theory called statutory employer. Now, if the general contractor, although has a subcontractor agreement with the roofing company or any other company that they subcontract work to, and that subcontractor has what they consider employees, even though the subcontractor considers those workers employees, it doesn't have insurance, and the courts can rule that the general contractor is the statutory employer or the fictional employer for purposes of that injured worker's workers' compensation claim. And the test used for statutory employer is much like I already discussed with whether or not a person is an independent contractor. So although you might be doing the right thing, you still can get in trouble for not going through the correct process of ensuring that your subcontractors have workers' compensation insurance should you have them. And if anybody is in that situation that they contract work out, I'd be happy to talk more about that. You can type a question in the bottom of the program that we're using, and Mr. Bosser will be able to tell me that. So how do we know if your business or any business needs workers' compensation insurance? Well, the test is pretty simple. Pennsylvania law requires that any employer who has even a single employee carry workers' compensation insurance if, and there are 3 prongs to this test, or 3 scenarios in which an employer will have to purchase workers' compensation insurance. And the first is pretty clear: if the employee is hired to work in Pennsylvania. Even if the employee is hired to work in another state, Pennsylvania law would require that coverage be carried if the principal place of business is Pennsylvania, but the employee is being hired to work in another state. In addition, your business will be required to carry insurance even if the employee works out of the state, but the contract for hire was made in Pennsylvania. If anybody uses union labor, this third prong is very important. Some union halls are in New Jersey, although all of the work happens in Pennsylvania, or vice versa. All the union halls in Pennsylvania and all of the work happens in other states. Because the work is directed out of the union hall and the contract for hire is made out of the union hall, but the work is performed in another state, there's a choice of venue. You could file that workers' compensation claim in the state in which the injury occurred, or you can come back to Pennsylvania because the contract for hire was made here. Pennsylvania has one of the top 3 most worker-friendly and complicated workers' compensation systems in the country, just a shade behind Texas and California. New Jersey has a very restrictive workers' compensation scheme. So where a business is located in Pennsylvania or a contract for hire is made in Pennsylvania, but the injury occurring in New Jersey, typically what happens is that the injured worker files for benefits in New Jersey, which are for a short period of time, and then they come to Pennsylvania and try to get all the Pennsylvania benefits as well, and that's permitted by law. So those are the 3 tests, the 3 scenarios in which a business in Pennsylvania will be required to purchase workers' compensation insurance. There are exceptions to these rules, thankfully, because the exceptions, these intricacies in whether or not you need insurance or whether or not you have a claim, is why lawyers like me have jobs. So they're very important. And I'm not getting the slide to move to the next. There we go. If your business is a general partnership or a sole proprietorship, you do not need to carry, you're not required by law to carry workers' compensation insurance. So if all of the employees are owners, those owners are not required to be covered by a policy. You have to, if you are comprised of both employees and owners, owners can waive coverage. So if you're purchasing a policy, say you have 5 employees that are true employees, not owners, and there are 2 owners of the business as well, making up 7 people who staff this business. You as the owner can waive coverage for yourself, but you have to do that in writing. Now there's a very sad example that I've been involved with regarding an owner waiving coverage. There was a fairly large farm in Berks County, and one of the it was a dairy farm, but they also grew crops under contracts with certain companies. And under those contracts, they had to use certain pesticides and fungicides on their crops. One of the farmers who was a principal owner of the farm, he was one of the 2 sons of the father who owned the farm, and the 3 of them owned it together. They had multiple employees. It appeared that they waived into coverage after years of waiving out of coverage. Unfortunately, the form that's required to waive back into coverage was never properly received by the insurance company. The premium was not adjusted to include those 3 owners as employees covered under the workers' compensation policy. And that was years prior to one of these farmers developing a very aggressive form of cancer that, under the science, is very closely and solidly related to the type of fungicides and pesticides that were being used on the farm. So he had an occupational disease claim that, from a causation perspective and from the medicine, was an occupational disease. However, he never waived back into coverage. So that farmer and his family were denied workers' compensation benefits because he wasn't covered under their policy. Additionally, There are injuries that occur to the owners, especially if there's travel involved. So it's always my recommendation that owners of a business be covered along with their employees. And that goes to the last point. The second point on this slide is that even if you're not required by law to carry workers' compensation insurance because you're comprised either of just yourself or you and other partners, it's not ill-advised to carry the coverage because things happen and you know, you don't think you need this coverage until you actually need it. Okay. So that's the piece about what workers' compensation insurance is, who needs it, who doesn't need it. Now this is going to be as boiled down of a analysis of what workers' compensation claims look like, how they're handled, what types of benefits there are. Um, Workers' compensation can be really simplified into two things. There are ways to turn benefits on and ways to turn benefits off. It's just like a faucet. Now your workers' compensation carrier will administer your claims for you. From an employer's perspective, there are certain things that you need to do as an employer, such as a first report of injury. Say, for instance, an employee is working in your ribbon factory, and you see that person trip over something that was left on the floor. The person gets up and they clearly have a broken wrist or a broken forearm. There are obligations on an employer for reporting that injury to their carrier and to the Bureau of Workers' Compensation. If you have a workers' compensation insurer, you report it to the insurer through a first report of injury, and they handle the claim from there. Whether the claim is accepted or denied as compensable is something that is done by the insurance company. They'll review either with their in-house counsel or with their attorney, or maybe just the adjuster through years of experience will know without much consultation whether or not this is a work injury and should be paid. There are multiple ways to do this. If you don't believe that there's a compensable work injury, so if a worker comes to you and says, you know, a month ago nobody saw it, but I was getting out of the truck and I twisted my knee and now it's, you know, hurting and I need to go out of work, I need to get some treatment, that's typically something that will be denied unless there are corroborating factors that allow the insurance company to establish a timeline that might make sense for this injury. But maybe you do some investigation and the guy who said twisted his knee plays in a bar league, softball league, and somebody else saw him playing, you know, he slid into second base and he got up saying, ouch, ouch, my knee, realized that he's going to need some treatment for the knee and decided to make up a story that he heard it at work. Those aren't made up facts. Those are facts of a case that I just had the other day. So a denial would be issued. That's the notice of workers' compensation denial. Conversely, if you have the woman who falls in the factory and breaks her arm and everybody sees it, a notice of compensation payable would be issued. That person would then get the medical treatment. If they have to miss work, they would receive wage replacement until they were either fully recovered or were able to return to work without wage loss. There is the ability in cases where the injury isn't clear, but it seems more likely than not that the injury occurred either in the course and scope of employment or on the premise. This notice of temporary compensation payable is something that allows the insurer and the employer to investigate the claim a little bit. After 90 days or within that 90-day period, the insurer or the employer has the ability to revoke the temporary notice of compensation payable or convert it into a notice of compensation payable. But it gives you that 90-day window to investigate the claim while paying benefits without the obligation of paying benefits past those 90 days. Um, that notice of compensation, of temporary compensation payable, has not always been a tool that we've had, but is a very useful tool in really getting down to whether or not these claims are legitimate.
Yeah, excuse me for a minute, Chris. I just want to let people know, and I should have said this at the beginning. We're getting a couple questions, which is good. Again, in your dashboard on your screen, there is a place to type out questions, and there will be time at the end to address these questions in detail. And this session is being recorded, and everybody in a day or so will receive an email thanking you for attending and a link to this presentation. All right. Sorry. Go ahead, Chris. I'm sorry, Chris.
Do you want to take the questions at the end, or do you want to address
No,
them
I
as they
think
come up?
they're very good questions, and we should wait till the end. There's some
Okay.
complicated questions for you.
Okay, so let's assume that the parties can't reach an agreement as to whether there was an injury or whether there was not an injury, and a notice of denial was issued. The worker would hopefully seek an attorney and file a claim petition. In a claim petition, a person is alleging an injury that they have the burden to prove occurred in the course and scope of employment or on the premise. These claim petitions go to the Workers' Compensation Office of Adjudication, which is a division of the Pennsylvania Department of Labor and Industry. These are administrative law proceedings. Um, the process has been formalized over the last maybe 15 to 20 years and is becoming more refined as we go. Workers' compensation judges are now judges. They're no longer referees. And all of the workers' compensation judges, with the exception of a few um, older judges, are all now required, and have been for the last 20 years, required to be lawyers. The hearings that occur are handled in a variety of different ways at the discretion of the judge. Some are held more in trial fashion. Some are held more in a piecemeal fashion, but they all require the presentation of evidence from both sides. Um, your workers' compensation insurer will provide counsel unless you have a policy that allows you to choose counsel. Your insurer will have any number of attorneys that handle workers' compensation defense. These workers' compensation judges handle the original adjudication of the claim, so whether or not there was an injury. And like I said, there's turning benefits on and turning benefits off. These judges will also hear petitions to terminate benefits or to suspend benefits for some reason. They can decide issues of the reasonableness and relatedness of medical treatment, and any number of issues that come up in workers' compensation litigation. We have an administrative appeals body called the Workers' Compensation Appeal Board. If you don't like the decision that the judge made, or you think part of it needs to be modified or reversed, modified is a bad word. If you think part of it was in error, you can file an appeal to the Workers' Compensation Appeal Board. That's also within the administrative agency of the Office of Adjudication under the Bureau of Labor and Industry. And that you always have the right to file your appeal with the Workers' Compensation Appeal Board. They have to hear your case. After a period of time, they'll issue an opinion either affirming the judge's decision below or maybe reversing and sending it back to the judge for maybe a different interpretation of an issue or two, or reversing it altogether. If you don't like that decision, you can appeal to the Commonwealth Court. I was at the Commonwealth Court earlier today. Not many cases get filed at the Commonwealth Court, and they don't issue a lot of decisions, but they have to hear your case if you file it. They have to at least look at it, and they might not take argument on the case, but they'll render a decision or render an opinion. If you don't like the Commonwealth Court's opinion, you can file for leave. It's called a petition for allowance of appeal to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court is a discretionary court. They don't have to hear your case. They can reject your petition for allowance of appeal. Very few cases get to the Pennsylvania Supreme Court. I think in the 2016 calendar year, they only took about 8% of cases that were filed. So review by the Pennsylvania Supreme Court is unlikely, but on a novel issue, they may take it. I have a few cases there right now. So they are hearing cases. Choice of healthcare provider is a hot issue right now in the next legislative session. Currently under Pennsylvania law, within the first 90 days of an injury, an employer can control who the healthcare providers are that treat their injured workers if they choose a company doctor. A company doctor is typically a panel of 6 physicians that have different specialties. Typically there's always an orthopedic physician on that list, primary care, and then you can choose a number of other types of doctors. If you have a business that might have eye injuries, then you can choose an ophthalmologist. If you have a business that might have some type of common injury, you can choose specialties. Maybe pulmonology or respiratory doctor would be a choice. Within the first 90 days following the injury, the employee must treat with the panel providers. The panel is chosen by the insurance company, and it's a useful tool in keeping claims from running out of hand. Typically, if there's an orthopedic injury, a muscle strain, or some sort of joint sprain, you can get your person back to work in 90 days, or you should be able to get your person back to work in 90 days. Even if it's a heavy job and you provide alternative employment, you can get them back to work. So the panel system is meant to be a barrier to out-of-control claims. If the injured worker decides not to see the panel, payment for that treatment can be denied within the first 90 days. There are, unfortunately, physicians in Pennsylvania who make their living in workers' compensation type treatment, and you always know the type of case you're going to get if you get one of these doctors. They can overtreat. They can provide treatment that might not be related to the work injury, but know exactly how to get that treatment paid for. And they make their living doing that, and they make very rich livings doing that. So panel providers are this great gateway to preventing the claimants, your injured workers, from getting to the doctors who will tell them they'll never get better and will overtreat and provide not very effective treatment. This next slide talks about the type of compensation benefits available under the Workers' Compensation Act. Temporary compensation benefits are wage replacement or wage loss benefits. Don't be fooled by the term temporary. There's nothing temporary about these benefits. We don't have a permanency provision in Pennsylvania like they do in New Jersey or in other states. Typically all injuries are considered temporary, but there's temporary total disability and temporary partial disability. People can be on temporary benefits for their entire life or the remainder of their life. A temporary total disability benefit is calculated by the average weekly wage of the person. So if you have a salaried employee, that gets pretty easy. If you have hourly employees, it can be a little bit more difficult, but essentially the calculation is of an average weekly wage is a snapshot of a 52-week period prior to the date of injury. Those 52 weeks are broken into quarters. The lowest earning quarter is eliminated, and the average of the three highest quarters is taken and divided by the number of weeks in that quarter to come to an average weekly wage. That average weekly wage will correspond to a workers' compensation rate. And there's a schedule of workers' compensation rates that you can find online. The Bureau publishes them. The maximum compensation rate in Pennsylvania for the 2017 calendar year will be $1,000 a week. To get that $1,000 a week benefit, you have to fit within a income bracket. From there, there are other tiers if you're within a certain, so it looks like these are the 2016 numbers. If your average weekly wage was $1,468 or above, you would reach the maximum compensation rate of $978 a week. If your earnings were $733 a week to this $1,467, you would get 2/3 of your average weekly wage as your compensation rate. If you're between $543 a week and $733 a week, your compensation rate would be $489. And if you're below $542, you get 90% of your average weekly wage as your compensation rate. Importantly, workers' compensation benefits are non-taxable. So if you're in that 90% of your average weekly wage compensation schedule, so if you're making $542 per week and your compensation rate is going to be just over, just under $500. It'll be $498. That's tax-free, so you're not losing what you would regularly pay in taxes, and you would actually be earning more on workers' compensation benefits than you would if you were actually working. Work is hard, especially for people who have low wages. It's typically manual labor or some otherwise not very glamorous job. Those people are very hard to get back to work given the tax-free nature of workers' compensation benefits. The next type of benefit is called specific loss, payable for amputation, loss of use of a body part, or scarring. Interestingly, scarring in Pennsylvania under the Workers' Compensation Act is only compensable if that scar is permanent, unsightly, and occurs above the collarbone. So basically head and neck scars. Another thing that the legislature will be debating this year in the 2017 calendar year is whether or not to include scars on other parts of the body as compensable disfigurement. Disfigurement can be very expensive. The rule of thumb is that 10 weeks of benefits is provided for every inch of unsightly scarring on the face or neck. So a 3-inch scar for a person whose average weekly wage is $1,000 a week, which will be pretty close to next year, it could be a $30,000 scar. So it can be very expensive. There's a scheduler in Pennsylvania for loss of use of body parts and for amputations of body parts, and that will correspond to whatever the Act says. So a number of weeks for, say, the loss of use of a leg, I think is 250. So you would get 250 weeks of benefits if you lose a leg or lose use of a leg. Beyond wage loss benefits and specific loss are death benefits payable if the death is work-related. Most of my workers' compensation litigation is focused on cancer claims, and I have probably half of my claims are fatal claims. In Pennsylvania, if a person has an occupational disease or an injury and dies as a result of that occupational disease or injury, there are a couple different scenarios. The most typical scenario is not having dependent children, in which case the surviving spouse of the deceased employee would receive 51% of that worker's average weekly wage up to the maximum workers' compensation rate, which again in 2017 will be $1,000 a week. So if the deceased employee earned $2,000 a week, they'll get that max comp rate because it's 51% of the average weekly wage of the deceased employee. In addition, like we talked about, medical benefits are payable under the Workers' Compensation Act. It's only for reasonable, necessary, and related medical care. There's a fair amount of litigation over those issues. An employee can file a utilization review petition asking a physician, asking the Bureau of Workers' Compensation to designate a physician to look at whether the treatment being provided to the injured worker is reasonable and necessary. You can also file a petition regarding relatedness, and that's a different petition. Okay. Now what happens when one of your employees has a workers' compensation claim? An employee may not be terminated for filing a workers' compensation claim or seeking benefits. Efforts should be made to accommodate physical restrictions that result from a work injury. So if a person's job is a sedentary position like a secretary or something that doesn't require heavy lifting and doesn't require a lot of manual labor, that's pretty easy to allow that person to get back to work. You can allow them to sit or stand at their leisure and to work at their workspace in any manner they want. It gets a little trickier when you have workers that require or have heavy duty lifting as part of their job description. If you return a person to work and accommodate their physical restrictions, you will not owe them workers' compensation wage loss benefits so long as that job pays them the same amount that their last job paid them, their full duty job. If you get a letter from the doctor who's treating the claimant or the injured worker, and that doctor says claimant can not do her pre-injury job, but is able to do a job that would require, choose your restriction, lifting of no more than 5 pounds, ability to sit or stand as the person needs, and no driving because they're on medications. Well, if you can accommodate those restrictions and the person still refuses to return to work, you can ask a judge to suspend that person's benefits because you made them a job offer. That job offer is within their physical restrictions, and they're refusing to take it. An employee cannot do that and still collect workers' compensation benefits. So light duty programs or sedentary duty programs, return to work programs are always a part of the employer's responsibility to mitigate their own losses for workers' compensation benefits. I'm having trouble. Oh, there we go. Now, like I said, workers' compensation is all about the turning on of benefits and the turning off of benefits. When a case is referred to an attorney like me to try to mitigate the loss or to try to limit the benefit of the injured worker in some reasonable way, we have plenty of tools to do that. Independent medical examinations are an important part of litigation of workers' compensation claims. We discussed that 90-day window in which the claimant has, or the injured worker has to treat with the panel physicians if you have them. Once they get out of those 90 days, they can transfer care to another provider, and that provider can and often will write letters for them to get them out of returning to work and maybe inflate the symptoms or the work restrictions. An employer and its workers' compensation insurer are entitled to independent medical examinations on a periodic basis. And that would be choosing a physician who's not treating that claimant to perform a physical examination, review the case, review any diagnostic studies, and provide an opinion as to whether or not that person is still injured, whether or not they're able to work in any capacity, or maybe they're fully recovered. If you get an opinion of full recovery, you can file a petition for termination of workers' compensation benefits asking a judge to rule that that injured worker is no longer injured and that the injury has fully resolved and that employee is fully recovered. A full recovery, if believed by a judge, will result in the termination of all workers' compensation benefits, including wage loss and medical. We talked a little bit about suspension of benefits as a result of a job offer that was not accepted, that was within the restrictions. You can also have a suspension for failure to receive reasonable medical treatment that might mitigate the injury or resolve the injury. So if a person just refuses to have a knee surgery to repair a torn knee, you can file a petition asking a judge to suspend their benefits until they have that treatment that might help resolve the work injury. There's also this concept of impairment rating evaluations. A person will be on temporary total disability payments while they're out of work, and those benefits can go forever, so long as they're fully disabled from work. After 2 years of paying TTD benefits, or temporary total disability benefits, an employer can have this impairment rating evaluation to determine the injured worker's whole body impairment. How much is the work injury impairing this employee? If the impairment rating evaluation comes back at 50% total body impairment or more, the person can stay on total disability benefits until they become no longer disabled, or until their impairment rating goes below 50%. If the impairment rating evaluation is under 50%, you can cap their benefits to 500 weeks, or it's about 5 years, 5 months. If a judge believes that that person is, only 20% or 30% disabled. Again, we discussed the job offer, and all these tactics, and there are many more that I didn't list, are all tactics to try to limit the exposure for an injured worker. So that is the end of the slideshow. It leaves us about 10 minutes for questions. A little bit about my office. Chartwell has attorneys all over Pennsylvania handling employment law and workers' compensation defense, among many other practice areas. Like I said, we have cases from the judge level to the Pennsylvania Supreme Court. I have cases from the judge level to the Pennsylvania Supreme Court. We also have attorneys in New Jersey, New York, Florida, Tennessee, Massachusetts, Connecticut, Rhode Island, Ohio, West Virginia, and Georgia. So if your business does business in any of those states, we have people in those states handling, in most of those states, workers' compensation or other types of law. And the final bullet is our website. If you have any questions, you can always visit our website and get contact information for me or any other lawyer.
Okay, great, thanks. We do have a couple questions, and we'll start off with the question from Tom. Tom says, I'm a landlord. I need to hire a painter and carpet repair person. Do I need to carry WC coverage for these contractors?
Can you repeat that one more time? I was just getting a pad and a pen.
Okay, I'm a landlord. I need to hire a painter and a carpet repair person. Do I need to carry WC coverage for these contractors?
It's an interesting question. No, I don't think you would, but that's that's why lawyers make things complicated. The answer is most likely no. As a landlord, you're hiring contractors to come in and do work for you, and you would want to get a certificate of insurance from those people to make sure that they had their own insurance. But I would say typically no, you don't need to carry workers' compensation insurance for those contractors that would come in.
Okay. Um, uh, Tim, or not Tim, Tom, if that didn't answer your question, you can click your dashboard and raise your hand, and we can come back to you. Tim asked a question. It's a long one, but it's a good one. I have a
Okay.
single member LLC management consulting firm. I may be using two 1099 consultants for a short-term project. Most of the work will be remote for them on their own time schedule outside of weekly client updates. What if they have an on-site meeting at the client and something happens? Slip and fall, etc. Is workman's comp required by me, them, or none?
Okay. So when you say a single member LLC, um, I'm taking that to mean that you're the only person working for that group.
Right, Tim.
Single member.
Tim, I unmuted you. If you're hooked up to the audio, you can answer.
Yes, that's correct.
Okay, good.
So you're not required to carry workers' compensation insurance for yourself. If you
Right.
have consultants working for you and you're paying them via 1099, either on an hourly basis or on a project basis, and let's assume that those are also single member sole proprietorships. You're saying they're coming on your work site, on your in your building or on some work site that you're working on to provide essential services. Um, it's not a cut and dry answer. The answer, again, is most likely no, you don't have to carry the workers' compensation insurance for those people because they're not employees. They are, in fact, independent contractors. Um, but the waters can be muddied. Let's say, you're single member LLC and that's the name of your business. At these on-site meetings where they're talking to clients, are they wearing your logo? Are they introducing themselves as, hi, I work with Tim? Um, those all can be factors that lean towards them maybe being employees, but it's a pretty long shot for that to be the case. In the facts that you gave me, that you have 1099 consultants who work periodically for you, either on part of a project or on a project, and they work for themselves remotely and come on site for a meeting, workers' compensation insurance would not be the appropriate insurance that would cover an injury in that scenario.
Okay.
Okay.
Does that,
But I
does that
would
answer
probably
your
need to
question?
carry, yes, I'd probably need to carry general liability insurance or and professional liability insurance for myself, though.
Yes. Anytime you have anybody coming on your premise, you're going to want general liability insurance.
Right. It wouldn't be on my premise. It would actually be on the client's premises.
Okay. Still, though, I think general liability insurance is the way to go. Again, you don't need to cover yourself through workers' compensation, but if you're traveling a lot, it's never a bad idea.
Okay.
Thank you.
A very similar question Chris, from Todd. If you're a sole proprietor, excuse me, if you're a sole proprietor and hiring an independent contractor to work on rental properties, again, am I responsible for workman's comp? Even if I know they don't have it.
Again, Todd, that is a question that doesn't have a very clear answer. It's pretty much the same answer that I've given for the last two. Most likely, no. If you are hiring, say, a cleaning service to clean a rental property that you have, while it's always a good idea to have general liability insurance for any business, and it's always a good idea to get a certificate of insurance for anybody that does any kind of work on your property, it wouldn't fall on you to cover them for workers' compensation because they're not your employees, because you're hiring them for essentially you're hiring them for a specific job as opposed to that's your business. Your business is renting properties. Your business is not cleaning. So my answer again would be I can't say 100% because facts of every case can dictate the case. But what you're telling me, again, that's not your employee and you wouldn't be liable for them for workers' compensation. But I would always recommend getting a certificate of insurance for anybody coming onto your property or premise or workplace or any event that you're in control of.
Okay, and our last question is from Press. I work from home once in a while. If I get injured during work hours when working from home, which insurance, my homeowner's or workman's comp, should cover it?
It's a very, very good question. Working from home has become uh, much more common. Again, it's one of those it depends questions. If you're working from home because you're sick and you're trying to get some work done on your computer, that's a different scenario from you're a full-time employee that's required to work 5 days a week and your employer has a policy that you are required to come in to work only 3 days of that 5-day work week. What I'll tell you is that the law is evolving with regard to work at home. So the answer is yes, you probably would be covered under workers' compensation insurance for your employer if you're permitted to work from home, there's a standard policy that you can work from home, and or you declare a workspace on your taxes and your employer allows you to do that, and you're injured within that premise. It does become your workspace. There's going to be a question in cases like that of whether or not the activities you were performing at the time were in furtherance of your employer's business, therefore taking it within or without of the course and scope of your employment. So if you're working from home and your job is to be on a computer, interacting with other people at work or working on a computer, and you trip and fall getting, in your kitchen getting a sandwich, those are different facts than, if your job is to produce binders for training modules and the 3-ring punch punches a hole in your hand, well then that's a different set of facts as well. So all of the questions have been very good questions in that there's not a clear answer. There's a pretty solid answer, and it will all be fact dependent. So I hope
Okay.
that answers your question. Unfortunately, all of the questions have been, it depends, which is
Okay.
a good
Okay,
thing.
great. So again, thank you everybody for coming out tonight. We appreciate it. I hope that it was informative and helpful. Please remember that to watch your email next January. In the middle of January, we'll have our next webinar Wednesday. I think the topic at this point will be hiring and HR, and some very good information as well. And certainly, again, I will send you an email. It takes about a day to get the video from the software. They render it or what, I don't know. It takes a day or so, but then I will send an email with that link, and you're welcome to share it or whatever. And if you need the services of SCORE Counseling, just go to our website and we'll be eager and anxious to help you. Thank you, Chris. We appreciate your time. With that said, I think that's it. We'll say over and out. Thanks again.